Okay. Kenyatta is already going out. See.
Do you normally sit on this side? Okay, okay. Yeah, okay.
Njag, 368 of 2026.
It may please your.
My name is Kirumba.
Yes, I'm so sorry. It's the practice in other courts for senior counsels to introduce the quorum, so I apologize. Yeah, okay. Thank you, Your Honor. My name is James Orengo. I appear together with the following counsels: Honorable Babu Owino, Mr. Eric Unjiri. Yes. Mr. Joseph Ouma Moga. Yeah. And also would like to place on record Advocate Senator Manzo and Senior Counsel Martha Karua.
Is coming up for mention of this matter. The respondent had been remanded at a senior police station. Yes, pending investigations. The IO is in court to update the matter. The IO is in court to update us on the status of the investigations.
We hear them, Pastor. Do you listen? Why wouldn't you want the status there?
Inspector Thomas.
I just don't know what type of material you want to go on record, because he's got to give a statement. Then we're entitled to confront him with our position insofar as this matter is concerned. So I would suggest that it would be more appropriate to swear him so that what he says goes. Yeah, yes.
Your Honor, I swear by the Almighty God that the evidence I shall give before this court touching the matter in question shall be the truth, the whole truth, and nothing but the truth. So help me God. Your Honor, I am number 235263. Chief 235263. Chief Inspector Eric Kumbasa.
You can sit down. Eric Kumbasa.
Yes, Your Honor. Currently, Your Honor, I'm the officer in charge, DCI Kitengela. Your Honor, we are before you for reason that on 24th June 2026, a team of DC officers arrested the suspect, one by the name Babu Njag, for the alleged offense of treason contrary to Section 40 of the Penal Code, Your Honor. Your Honor, our investigations were prompted based on a viral video which was circulating and done by the suspect before the court, Your Honor, with others not before court, whereby, Your Honor, in the viral video, the suspect before you, Your Honor, with others not before court, were heard saying that they would have maandamano and mapinduzi on 25th June 2026. Pardon, Your Honor. Maandamano and mapinduzi come 25th June 2026. Your Honor. Your Honor, we did arrest, as I've indicated earlier, the suspect before the court for the alleged offense of treason, and on 25th, we did present the said suspect before the court, namely Babu Njag, and we sought the custodial orders under the miscellaneous criminal application number E368 of 2026. Your Honor, at the time of arrest, we did confiscate 2 mobile phones, make Samsung, of the said suspect before court, and Your Honor, in our miscellaneous criminal application number E368 of 2026, we did request the court to grant us with custodial orders of 14 days, and the court did grant us 7 days to allow investigations to be complete. And the suspect before the court, Your Honor, was directed by the court to be remanded at the senior police station, Your Honor. Your Honor, we did get the communication from the office of the ODPP that the suspect before you through his defense counsel did make an application before the High Court. Case number HCCC RR EV stroke H double C double R EV stroke E028 stroke 2026, whereby, Your Honor, the defense counsel representing the suspect before this court, through that application, the High Court did grant bail to the suspect, that the suspect to deposit a cash bail of 100,000 Kenya shillings. And Your Honor, amongst the terms the High Court granted, is that the applicant to attend to the lower court proceedings as scheduled, and as a matter of fact, that's why we are before you, Your Honor. And the High Court did also indicate that the
there's no charge on the
applicant
file.
to report to DCI Kitengela at noon from every other day with effect from 3rd July 2026.
Report bail.
If I may read, Your Honor, as it's captured in the order of the High Court, it says that the applicant, in this case the applicant, I'm talking of the suspect in my case of treason, that one Bob Njag, that the applicant is hereby directed to report to the DCI Kitengela at noon every other day with effect from 3rd July 2026. Your Honor, as I had indicated earlier, when we arrested the suspect before you, Your Honor, we did confiscate mobile phones, 2 Samsung mobile phones. And we did request the court to grant us orders compelling the suspect to share with us the passwords of the mobile phones. And Your Honor, the court did indicate that it will amount to self-incriminating over the same. But the court did indicate that as the DCI, we can use our own means available to bypass the passwords of the 2 mobile phones. Your Honor, regards the same, the 2 mobile phones have been subjected to forensic analysis. They've been taken to our forensic laboratory based at DCI headquarters. And Your Honor, so far, we've not gotten the forensic report over the same. Your Honor, we do believe through intelligence that the said suspect regards the offense being alleged offense of treason. Through intelligence, Your Honor, the said suspect is a mobilizer and a financier of the youth.
Your Honor, would he be allowed to say that? That is Speculation.
I take it you are an objection
Yes.
to mean you agree with what he said.
No, I don't agree with what he's saying. Yeah, because he has not laid a basis for it.
Yes, Your Honor. So based on that, Your Honor, I understand the miscellaneous application we requested and granted the 7 days as elapsed today. Through this honorable court, Your Honor, I would request that the miscellaneous application we did regards the custodial orders and putting into consideration that the High Court has issued the cash bail of 100,000. We are very much, as the DCI, we are very much okay with that. But this honorable court, Your Honor, I would request that the miscellaneous application we did as the DCI remain open.
Can you find out for him
Give us
whether he's
more
being
time.
charged or read a caution charge?
Because the evidence regards the alleged offense of treason against the suspect before this honorable court, Your Honor. Your Honor, as I've indicated, through intelligence, the said suspect is involved in mobilization.
No. This intelligence. We're in a court of law. Yeah, in a court of law.
That is all I have, Your Honor.
But you've not told that, so you say that within a spy
I am requesting in this honorable court through you, Your Honor, that the miscellaneous application we did make remain open, considering that the High Court, of course, did issue bail to the suspect. We don't, as the DCI, we are very much okay regards the same, but I'm requesting in this honorable court through Your Honor, through you, that the miscellaneous application we did remains open so that we can finalize our investigations, Your Honor.
How does the defense wish to deal with the submissions?
Yes, if you may allow to cross-examine, and with your permission, you would allow one or two of us to undertake the cross-examination. Yes, I'll start and...
I think you can do it and make submissions on some aspects
Yeah.
of the Constitution.
Yeah.
But I thought he had said, unless I didn't get in mind, that they have complied with the High Court directive granting him bail so that he is now free.
Yeah,
And the High Court
still.
saying that he'll be reporting. You said,
This year you can get a happy mood.
senior level, you have the order of the High Court.
Yeah, the team will have it.
So I
Yeah,
thought
yeah.
I had him say that I don't have the order of the High Court. I had him say that he is now free and he should be reporting to the DCI. They didn't otherwise.
That is a question.
So based on that submission, will there be any need to further engage the senior level?
Yes, the engagement is because, the High Court, as it should, if there was going to be a trial or charge, it is this court which has jurisdiction. And with the matters that have been placed before you, and considering the provisions of the Constitution, you can make appropriate orders, considering the fact that there may be no basis at all whatsoever to make the suspect subject to these proceedings. And if Your Honor agrees, I can proceed to cross-examine. Because our position is that these proceedings before you, if you can persuade you, should not take place. And if the High Court had absolute authority and jurisdiction on this matter, they have not referred this matter to your court. Because this is where the miscellaneous application was made. If there was a charge of treason, then it will not be dealt with in this court. Yeah, so, yeah.
Your Honor, I may interject maybe among the conditions or the terms the High Court did grant under point 4. The High Court did say
this one is only triable by the High
that
Court.
the applicant shall attend the lower court proceedings as scheduled.
Yeah, so anyway, we have understood. Now, for how long? How long have you been a police officer?
I've been a police officer since 2011.
2011. And in your experience or work as a police officer, have you ever investigated a charge of treason?
Your Honor.
Have you ever investigated a charge
Your
of
Honor,
treason?
this is my first time I'm investigating a charge of.
Yeah, you can just say yes or no so that we don't take a lot of time.
No,
Yeah.
no, Your Honor.
You have never. But currently you are the investigating officer.
Yes, Your Honor.
Yeah. Are you familiar with the charge of treason?
Yes, Your Honor, I'm familiar with the charge of treason.
And that in a charge of treason, you need to demonstrate an overt act, which
Yes, Your
is spelled out.
Yes, Your Honor.
And which court has jurisdiction to deal with cases relating to treason? Trial.
Your Honor, I understand.
Is the treason charge triable?
Treason is a serious offense.
Yeah. Is it triable by a magistrate's court? You know, you're a chief inspector.
Yes, Your Honor.
Yeah, and I would imagine that before you engage yourself in a process of investigating a serious charge like this one, you would know where you should take that charge or deal with that charge. Or maybe to put it this way, what about murder? Are cases of murder triable by a magistrate's court?
Your Honor, of course, cases of
That-
murder are triable before the High Court, and that's as I indicated.
Yeah, the same way you've answered directly and simply that they're triable by High Court. What about treason?
Your Honor, the offense of treason, as I've indicated, is under investigations.
No, why is it triable? I mean, the situ of trial.
Your Honor, as DCI,
Could you take a charge of treason before a traffic court, for example?
no, Your Honor.
Why do you take it?
Your Honor, the power to give consent to charge.
No, I'm not dealing with... No, please, Inspector.
Yes, Your Honor.
Just answer the question. The DPP is not here, unfortunately. Oh, it's here. The DPP is here. I'm sorry. Why is it tribal? If you don't know, you just say no so that we don't spend too much time here.
Your Honor, what I'm saying, as the DCI, as Counsel, Senior Counsel Orengo has indicated, regards the offense of treason, of course there are ingredients you have to prove.
No, I've left ingredients. That's why I was talking about the. Why do you? Once we have a proper, please. Thank you. Yeah.
Your Honor, over the same as will be guided by the ODPP, Your Honor.
You don't know. You know, 30 years ago I was dealing with a case as serious as this.
No, just because the ground
Yeah, okay. Then tell us. So you are waiting for the ODPP guidance?
Of course, Your Honor, as I've indicated, treason is a serious offense. The mandate of the DCI in this case to get the ingredients of treason. Upon doing our file, we forward the file to ODPP. Then the ODPP that wants mandated to give consent, whether to charge, whether there is sufficient evidence over the same for the suspect to be.
So you have never gotten that consent?
So far, Your Honor, we have not. The matter is under investigation.
The matter is under.
As I have indicated, we are requesting this Honorable Court, Your Honor, to.
Inspector, I want to ask you, because we don't want to take time. The ODPP has not given consent for you to charge the suspect with the offense of treason, has it?
It has not, Your Honor.
It has not.
And as a matter
No, that is enough. That is enough. So as we speak now, you have not confronted Mr. Njag with any offense. And you know how to confront a person under arrest or an accused person with a charge as a police officer.
Your Honor, as I've indicated before this Honorable Court, we did confiscate.
Have you confronted him? You know the police, what you do when you have a case against somebody you place under arrest and there is a valid or an intended charge before you put him into custody. Is there anything you have done in compliance with the law?
Your Honor, based on the viral video.
No. Is there anything you have done? Have you, for example, read him a charge under caution or under inquiry? Have you done that?
Of course, Your Honor, no.
No.
We have not done that.
You have not done that.
That is why we did.
No, that's enough. That's enough. So as we speak, you don't have a charge against the Mr. Njag. You are just undertaking investigations.
Yes, Your Honor.
Yeah.
The matter is under investigation.
Yeah. As you made the application to this court for holding Mr. Njag for a number of days, did you do it as the investigating officer, or you went or filed the proceedings through the ODPP?
Through the miscellaneous criminal application we did make, that is E368 of 2026, Your Honor, we did cite the citations.
You're the one who filed the application?
Yes, Your Honor.
Yeah, you didn't seek the advice or consent of the ODPP. Now, the big question that I want to ask you, why didn't you go to the High Court? Because that's where this matter rests. If you have a charge of treason, the place that you should have gone to obtain orders to hold Mr. Njag was the High Court.
Your Honor, regards the application we did make, that is the custodial and having the 2 mobile phones of the suspect in this matter is a matter as the DCI that can be handled by the lower court without necessarily moving the same to the High Court, Your Honor.
But you're on a charge of treason. The investigations were all about treason.
As much as, Your Honor, the charge is of treason, the lower court regards issuing the applications we did make, Your Honor, want to believe that the lower courts had the mandate to issue the custodial orders, and based on that, that is why, Your Honor, the court did issue custodial orders of 7 days for the said suspect to be remanded at the senior police station, Your Honor.
Mm-hmm. So at the end and conclusion of these 7 days, you don't have a charge, correct?
Yes, Your Honor.
At the end of these 7 days, you have not submitted a file to the Office of Director of Prosecutions?
So far, Your Honor, we have not submitted for reasons I've indicated.
No. That is good enough.
Yes, Your Honor.
As far as we're concerned, up to now, there is no file or proceedings before this court relating to the charge of treason.
Your Honor, if I may respond to that, as Senior Counsel Orengo has indicated, Your Honor, we have a file whereby, as the DCI, we are ongoing with the investigations, but so far we've not forwarded the same file to ODPP.
And if you send it to the ODPP, they may refuse or give consent.
Your Honor, we don't have an objection on that. Forwarding the file to ODPP, even before this honorable court, Your Honor, when it comes to, I want to believe, making judgment, it is based on the evidence adduced before this honorable court.
Now,
so the file we forwarded to ODPP will basically depend on what evidence is contained in that file, Your Honor.
Which you don't have. You are still
As
not...
I've indicated, the investigations are ongoing, Your Honor.
Now, our constitution talks about the right of arrested persons, not even accused persons.
Yes, Your Honor.
They have a right to be confronted with the reasons why they have been arrested. And secondly, if at all they are detained, they must be brought to court within 24 hours. That is a constitutional postulation that, you don't have the luxury, the command of the Constitution that if you really have a serious charge, then before you arrest, you must be very careful that you in a position to meet the demands and the command of the Constitution. That once you arrested somebody, my problem with what you have done, that you decided to arrest him and you don't have a charge and you are still undertaking investigations. You have not have a file to present to the office of the DPP. And you're required to present him within those many hours. Is it not playing around with the law?
Your Honor, as the DCI, our mandate is clear. We investigate criminal offenses. Your Honor, I understand Article 49 of the Constitution enshrines the rights of the arrested person. Your Honor, regards the suspect before this honorable court, our investigations were prompted due to the viral video.
No, viral, you know, you don't have a case. Whether it was viral or not doesn't matter. If you had a case, we'll be dealing with a charge, with witnesses.
That is why, Your Honor, when we presented the miscellaneous criminal application, based on our application, the court did grant us custody orders.
You know, a lot of times when you bring a matter to court, there's a presumption that you have a serious case. You have a cognizable case. And the courts do give orders with respect in good faith. But here we are now in circumstances where you are enjoying a court order of keeping an innocent person, because the law is that there's a presumption of innocence. You don't have a charge. You have not confronted him in the manner prescribed by the law with any charge. Your investigations are incomplete, or they are, and you are still carrying out investigations. And you don't know when those investigations are going to be accomplished.
I have already indicated before this honorable court that within 14 days, of which the High Court did grant bail to the suspect, if the court so grants that the miscellaneous application we did make remains open for justice to prevail.
Justice to prevail, and somebody stays in jail for 5 days in custody, police custody. For 5 days, there's no charge. The ODPP is not seized of the matter, because prosecutions are handled by the office of the Director of Public Prosecutions. And on the 7th day, you still don't have a charge. Don't you think, as my learned friend, Honorable Babu Owino, was saying in a latter case we did last week, that you are using the ammunition of the law to impose upon him a punishment that is not justified in law? I mean, how do you account for those 5 days without a charge? I mean, if you had a charge, I would understand.
Your Honor, maybe if I may ask the Senior Counsel, the DCI, our mandate is clear.
So now you will serve us a lot of time.
Yes, Your Honor.
Yeah.
Yes, Your Honor.
Mm-hmm.
As the DCI making the applications to allow us time to complete investigations, Your Honor, I want to believe...
So the way you rather arrest people and keep them in custody and say, let us investigate.
That is not the case, Your Honor.
Yeah, but it's the case here.
It was based on reasonable grounds that the said suspect before this honorable court is
you know, but the court believes you when you come as a public officer with an application and being a state organ in a working democracy, constitutional democracy, the presumption is that you're doing everything in accordance with the law.
Of which,
That's why the courts
of which,
give you these orders. I'm trying to explain. But now you've gotten these orders in circumstances where you don't have a charge. You have not completed your investigations. And as it is, you cannot prosecute without the consent of the ODPP. Why should he remain in custody without that consent for the ODPP?
Your Honor, as I've indicated, we did make a custodial application, miscellaneous criminal application for custodial for the court to allow us to investigations, to finalize the investigations so that we can arraign or upon forwarding the file to ODPP to advise us so that we can arraign the things as
Would you, for example, and I'm suggesting I don't have the power, the court has the power.
Yes, sir.
If the court told you, let Mr. Njag go, you go and do your investigations. When the investigations are complete, then you can arrest him.
Based on that, as the DCI will, of course, go as per the orders issued by the court.
So what I'm suggesting is completely hostile to your office. The reasonable thing, you take your time. You know, sometimes treason takes a year or 2 years. Are you aware of any offense of treason which has been ended up in a conviction in a civilian court in the Republic of Kenya? Can you point to me even one, except in the court martials?
On that, Your Honor.
Are you aware even of one?
On that, Your Honor, I'm not aware.
Yeah. So it's not your normal walk in the park when you confront somebody with the charge of treason. Now, I want to tell you what the charge of treason is. To imagine, encompass, the death of the president. In what you're investigating, is there anything in relation to that element of treason?
Your Honor, regards what we
Is there any?
regards what we are investigating.
No, I'm just asking you a specific question. The answer is yes or no.
No, Your Honor, but
Yeah.
treason.
Yeah. You've answered.
Yes.
I've answered. You have answered my question. The investigation you're carrying about, are they? And I would really be surprised if you said they are a basis. Are you accusing Mr. Njag for the offense of overthrowing the government of Kenya by law established?
That is, Your Honor,
Are you?
the line we are pursuing.
Are you?
For reason,
You know, offenses are normally clear. You know, I'm trying to show you that treason is very difficult to deal with. And the state normally, at least I know, I've worked as a prosecutor in the office of the DPP with very senior legal minds, including their former Attorney General, Charles Njonjo. I've worked with Chunga in circumstances where the issue of the offense of treason came into discussion. Do you truly believe because of somebody which was you found on a phone that you say was viral, which you have not quite accessed the content, that he was justified to say that Mr. Njag was planning to overthrow the government of Kenya.
Your Honor, it's based on the answer.
Do you truly believe? Miss, I'm asking you a specific question as a serious person.
We do, Your Honor.
Well, maybe you need just clubs and stones to overthrow the government of Kenya. Now, my last question.
Yes, Your Honor.
As the investigating officer, can the court give you time? And it doesn't need to give you time. Can you be comfortable with the court terminating these current proceedings, because they are proceedings to nowhere, there's no destination, and you're given your time to investigate, so that Mr. Njag does not have to report every day, you know? Why should he report? He is not an accused person. He is not be charged with any offense. Why should he be going to the police station when there is no offense? But you can have your time. And if you're ready with the charge, we can come here tomorrow and confront those charges. Why don't we do it the proper way as postulated by the Constitution? You bring a charge, and then we deal with the charge. Instead of arresting. This is pre-trial detention, pre-indictment detention. And if you are part of the conversation during the making of this current constitution, Article 49 was meant to deal with the old practice where the police would detain somebody on a holding charge. It didn't matter what the charge would be eventually, but I'm putting to you, you don't have a basis for holding on any charge, and you don't have any reason to undertake these proceedings, including the miscellaneous proceedings that you brought before this court. And this proceeding should be terminated until you're ready to come to court with something we can answer to. Do you agree with me?
Your Honor, I do not agree with the Senior Counsel Orengo. My prayer.
Ni kamata.
My prayer before this court. My prayer before this court, Your Honor, is to make the miscellaneous criminal application remain open as we continue with the investigations. Here the cyber forensic report from DCI headquarters, Your Honor.
I think I'll leave it there, so you submit. Okay. Mr. Gunjuri would want to ask some questions. So.
Hi, Officer.
Good afternoon.
I will begin with the video. You are making reference to a viral video, right?
Yes, Your Honor.
Please confirm. Is that the basis upon which you commenced? You actually arrested him on the basis of that video?
Yes, Your Honor.
And is that video part of the annexures presented before this honorable court when you presented the miscellaneous application?
Your Honor,
It's a simple yes or no, sir. Was that video annexed? Even a link to that? Suspicion. Is that the law?
Yes, Your Honor. In this case, we had reasonable grounds based on the viral video, whereby the suspect before this honorable court indicate that come 25th June 2026 regards the commemoration of the Gen Z that they were to have maandamoto
Therefore, you confirm to this court that you moved on the basis of mere words, right?
Your Honor, as I have indicated, the matter is under investigations. We have subjected the mobile phones for forensic analysis. Upon getting this report, we will forward the file to ODPP, Your Honor.
And officer, from that response, what I'm getting is that you admitted to court that you went through things the wrong way. You first arrested and now you want to do investigations. While the law provides you are supposed to investigate, find reasonable grounds and then effect the arrest. So from what you just told the court is that you arrested and now you want to investigate, right? All right, thank you, officer. As I conclude, you have been very, very insistent that Mr. Njag being in custody for the 5 days that he was pursuant to custodial orders granted by his honorable court, right? That is the position, right? Officer.
Your Honor, we did make an application that as the DCI, we were doing the investigations. We did confiscate the mobile phones of the suspect before this court, and that the said mobile phones were to be subjected or have been subjected for forensic analysis. So far, Your Honor, we have not gotten a report over the same.
I believe you went on a different tangent from your question, but okay. When you presented Bob to court for the application for custodial orders, were you present in court?
I was present in court, Your Honor.
When was that?
It was on 25th June 2026, Your Honor.
What was the situation in our country in that day, officer? You confirm that police officers had located and barricaded roads all over the country. Is that so?
Your Honor.
Is that so, officer? It's a simple yes. Well, it's in the public domain. Was Mr. Njag represented on that?
I don't know, Your Honor.
But you in court?
Yes, I was in court, Your Honor.
Was Mr. Njag represented?
Your Honor, maybe that question can be directed to the Mr. Njag, Your Honor.
Yeah, that is all.
Your Honor. May I come?
We need to do the submission. My colleague here will ask.
Joseph Mugaso.
It's important to start every conversation from the Constitution. What does Article 10 say? What is it about? No, you're not an advocate, so I will just I'll put it to you that you need to talk about good governance. And what is good governance?
You're not only the council.
Or not at all, sorry. Bwana Mwanza, do you know what Article 10 of this Constitution talks about?
Your Honor, I've gone through the Constitution, but at this time, regards what the Council is asking Article 10, I'm not privy to that. Maybe
it's a conversation. So Article 10 asks you, as a public officer, to pursue good governance. Now, it is quite clear that you made an arrest and you came to court and you sought orders to detain someone without probable cause. Probable cause. You do not see reason, but then that is not my point. I want to ask you a series of questions that will demonstrate to this court that the miscellaneous application you made makes you unfit to be a public officer.
We will not do that. That is what you want.
Your Honor, I won't railroad the witness. I won't railroad the witness, far be it from me.
He's not for trial.
We were just ventilating the miscellaneous application and looking at its merits and demerits.
So take the route for merit and demerit, but not being fit or otherwise.
Your Honor, we have a public officer here who has come to court.
Proceed with the questions.
Much obliged, Your Honor. You say that the DCI has been investigating this matter, yes?
yes, Your Honor.
The Act, the National Police Service Act, it says, and I quote, that the primary role of the DCI is to collect and provide intelligence.
Yes, Your Honor.
So far, have you collected any intelligence?
Your Honor, we did effect the arrest of the suspect before this court based on the intelligence.
So what did you collect?
The intelligence we got in collaboration with the viral video whereby the suspect before this court, Your Honor.
Thank you. Thank you. No need to repeat that. So the intelligence that you're providing as a result of that miscellaneous application is that there's a viral video.
Yes, Your Honor.
That prompts a charge of treason. Investigation, yeah? Leading to a charge. Now, the penal code, section 40, says that treason is, and let me read. Apologies. Treason and allied acts. It's a composition. Any person who, owing allegiance to the Republic in Kenya or elsewhere, devises, intends, invents, imagines the death, maiming, wounding, imprisonment or restraint of the president. Mandamoto Mapinduzi. Do we hear the name of our beloved president? Or any reference to him?
Of course not, Your Honor.
Thank you.
You can maybe continue.
Sorry. Secondly, the imposing by unlawful means of the president from his position or the style, honor, or name of the head of state and commander-in-chief of our republic. Mandamoto and Mapinduzi. Anything about overthrowing our beloved president? That's a yes or no question. And you watch the video. Any mention of our beloved president?
Your Honor,
It's a yes or no question.
I would request the council maybe to continue reading the offense of treason.
Yes or no? Please, let's respect each other's time. Huh? Did you hear the president being mentioned in any way, form, or shape?
No, Your Honor.
Thank you. Expresses or utters, declares any imaginations, inventions, and it's quite wide here. Imaginations, I believe Mandamoto fits there. Imaginations, inventions, devices, or intentions of publishing any printing or writing. Was anything printed? Was anything written? That's a yes or no question, sir.
The suspect in this case is doing the viral.
Okay, so there nothing was written, nothing was printed, yeah?
Is subjected to getting the reports from the cyber forensic.
Was anything written?
It is subjected to.
Was anything written?
Your Honor, it is subject over the same. The matter is under investigation, subject to getting the reports from the cyber forensic.
I have written on this paper. Was anything written? It's fine. I want to dive in. And lastly, any person who levies war is an enemy of the enemies of the Republic and instigates an invasion, which is irrelevant. Therefore, Your Honor, I apologize for that confrontational approach in the beginning. I believe an academic approach says receipts and locutor. That is, the facts shall speak for themselves. And that's it. So,
I'll advise you use your time to cross-examine.
yes. Therefore, in conclusion, you brought an application to court to investigate something which the evidence which you have not attached says nothing about. Because it's the president we're talking about here. Nothing in that viral video, or is there anything in that viral video which alludes, even distantly, to our beloved president?
Your Honor, based on the miscellaneous criminal application we did make, I do not think that the court did make or issue the custodial orders based on hearsay, what we presented before court, so that the DCA can be granted the custodial orders in its own understanding. I want to believe, Your Honor, the court did see reason for the application and they granted us with the custodial orders, Your Honor. As I've indicated, Your Honor, the matter is under investigations, and I'm requesting you, Your Honor, if you can allow us time to get the forensic report regards the mobile phones which have been submitted to the cyber laboratory for extraction of the videos. It will be prudent based on that, upon getting the reports as the investigating agency and to ODPP, Your Honor, it will be of great help regards the matter under investigation, Your Honor.
Conclusion. Thank you for the time. In conclusion, I submit to this court that the miscellaneous application was misplaced simply because the basic elements upon which the investigation should rest have no direct linkage to said offense as our penal code provides. Thank you for the time.
Mr. Orengo, are you done with your submission?
Yes. Yeah, I think the prosecution of the
DCP, any issue?
Yeah, no, we don't have much, because I don't want to delve into issues that are not for this matter. Our views, Your Honor, are that the DCI are requesting very simply that they be allowed to continue with the investigations, which investigations would include availing the investigation file to our office for directions. We are agreeable to that application, that you do give them a few more days to conclude the investigations, and on the next mentioned date that you give us, for them to come and give hopefully their final direction that they will have received on whether the respondent is being charged and what charges are going to be preferred based on the advice given by our office. The respondent is already out on cash bail as ordered by the High Court. That will continue we will maintain that position. I believe the High Court matter also has mentioned it for them to confirm the issue. So I request that we mention this matter. The respondent continues to comply with those orders of the High Court to report every other day to the DCI. And then you give us a mention date in this matter for final directions in this matter on the investigations. I think the officer does.
As we,
yes, that's
it. The DPP has said from your team.
Yeah, we went wherever Alexandra. We thought she was going to.
Who is going to the video?
Thank you very much, Your Honor. Your Honor, we are so disturbed by the manner in which the state is handling this matter. Just as a joke, Your Honor, because they did come before your sister, Honorable Susan, Your Honor, with a miscellaneous application and custodial orders were given. They requested for 14 days, and Your Honor, 7 days were given. And the court, in its own wisdom, believed that 7 days was sufficient for the DCI to conclude their investigation and charge one Bob Njag. And then again, Your Honor, today, we are being treated with infertile imagination. There are further
days be given, time, and they are not even telling you the amount of time that they require, Your Honor. If you want to know that the DCI is a joke, Your Honor, you are told that give us days.
We will not use those words. So refer to state agencies.
Your Honor,
I'm not clear.
You are clear.
Okay.
Your Honor, you are being told that we need more days. We don't know until when, 2050, 2100. How long do investigation? Your Honor, please stamp. This is a court of justice. And don't let me. There is no, the doctrine of specificity. They are not specific on what they want, but they are just telling us that they want to investigate. Your Honor, the norm should always be arrest, should always be investigate, make arrest, arraign. Then they are starting with arrest, put in the custody, then investigate. Your Honor, that is not the order of doing things, because that is infringing and violating on serious constitutional principles. One of their violations which states that an arrested person to be informed promptly he best understands of the reason the arrest was made. According to this case, Your Honor, because even the DCI is not sure of what to charge, of what charge to bring forth, and is still under investigation, it therefore means that the arrested person was not informed of the reason why he was arrested. And that amounts to abduction, Your Honor. Article 50 of the Constitution, Your Honor, on a right to a fair hearing or trial, Your Honor. This right cannot be limited, Your Honor, under Article 25C of the Constitution of Kenya. The Constitution does not treat this right as a procedural luxury, but instead it treats it as an indispensable pillar of justice. And Article 25C of the Constitution declares this right as a non-derogable. Right that must survive political tension that is being treated before us. Because Bob Njag was arrested on the 24th day of June, just a day before the maandamano, which is also enshrined, allowed in the Kenyan Constitution, right to picket and present petitions. It must survive political tension, public outrage, and even state of emergency, Your Honor. And this right cannot be suspended, it cannot be diluted or sacrificed at the altar of expedience, Your Honor. Further, Article 50, subsection 1, Your Honor, of the Constitution guarantees every person the right to have any dispute determined in a fair and public hearing before an independent and impartial court. Your Honor, justice is not merely about arriving at a conviction or acquittal. Justice is about ensuring that the road to that decision itself is fair. Therefore, Your Honor, this court must jealously protect this right. Your Honor, the state possesses immense investigative machinery, unlimited resources, and coercive powers. The accused person standing before you, Your Honor, only has the Constitution to protect him.
He is not an accused.
The arrested person standing before you, Your Honor, only has the Constitution to protect him. But according to the DCI, he is already convicted, Your Honor, according to the way, the direction that he's taking. Your Honor, I want to talk to you about administration of justice, Article 159. This court is not merely a forum for determining disputes, Your Honor. It is the constitutional custodian of justice. Every decision rendered by this honorable court either strengthens or weakens public confidence in the administration of justice. Article 159 of the Constitution provides that the judicial authority is derived from the people, and shall be exercised in accordance with the Constitution of Kenya. And the judiciary therefore exercises power on behalf of the people, not on behalf of the executive, nor the legislature, or any other private interest. The administration of justice is not measured by the number of convictions, Your Honor, number of convictions secured, or applications dismissed. It is measured by whether the process is fair, impartial, transparent, and faithful to the Constitution. Your Honor, justice administered under pressure ceases to be justice. Justice administered in fear ceases to be justice. And justice administered to satisfy the state also ceases to be justice. The Constitution of Kenya only requires only one standard, which is the constitutional justice, not any other. Therefore, the duty of the court is to validate actions, is not to validate actions of the state, Your Honor, merely because they are popular, nor condemn an accused person merely because of allegations such as this, just to attract public attention. The administration of justice demands fidelity to the law, equality before the law, and unwavering protection of constitutional rights. That is the promise made to every Kenyan by the Constitution of Kenya. Article 159, subsection 2, Your Honor, states that justice shall be done to all irrespective of status. It shall not be delayed, Your Honor, which is happening in this case. It shall be administered without undue regard to procedural technicalities, and the purposes and principles of the Constitution shall be protected and promoted. These constitutional commands are not aspirations, are not aspirational, Your Honor. They are binding obligations. They require this court to ensure that justice is not only done but is manifestly seen to be done. And Your Honor, history does not remember courts that merely followed the prevailing winds of the day. It remembers courts that upheld the Constitution when it mattered most. The legitimacy of the judiciary rests not on the popularity, but on the unwavering commitment to the rule of law. We therefore, Your Honor, respectfully urge this court, Honorable Court, to administer justice in accordance with the Constitution, uninfluenced by external pressures, and to reaffirm that in Kenya, the law remains supreme over power. Your Honor, the court exists not to ratify power, but to restrain it, not to echo the loudest voices, but to uphold the Constitution. And therefore, lastly, Your Honor, every judgment, every ruling delivered by this court is a statement about the kind of a republic we aspire to be. Today, Your Honor, we humbly ask the court to let that statement be one of justice, courage, and fidelity to the Constitution. Your Honor, we also request humbly, as you close the file, Your Honor, we humbly request that the gadgets, the phones that were taken away from Bob Njag be returned to him, Your Honor. All this is against the spirit of the Constitution, Article 50, subsection 2, paragraph L. But he cannot self-incriminate. And authority to that effect is Wilmington versus the DPP in the UK, 1935, AC 462, where Judge Viscount Sankey stated that the burden of proof lies solely with the prosecution, not the arrested person. So he cannot help the DCI officers to investigate himself. And therefore, the Constitution solely expressly protects Bob Njag from being compelled, directly or indirectly, to furnish evidence that may incriminate him. Because the burden of proof, proving this case, therefore the charge will solely rest on the prosecution. Thank you, Your Honor.
Are we done with your team now?
Yeah, I don't know, unless it is also, you know, I'm inclined to say that, you know, senior command, but were you putting us on mic?
Yes, I and I just wanted maybe to make on the CPC Cap 75 laws of Kenya, which lies with you, the discretion in that section lies with you, as to hold anyone pending investigations, Your Honor, and that what they seek to charge with, Your Honor, is under section 40 of the Penal Code, Cap 63 of the laws of Kenya, which is treason, Your Honor. And Your Honor, all around, what treason looked like a long time ago has now changed, Your Honor. Because this was compassing, imagining, inventing, devising. Your Honor, there's no investigation which can come up with what is happening in somebody's brain at any one given time, unless there's clear indication. Your Honor, you cannot commit treason unless you have an army of your own, which you have set up, you have guards, and it can easily be seen that one overthrow the government. Therefore, I am pleading with you, Your Honor, now that it's already been admitted to the order of the High Court, that whatever is being sought today be denied. From Njag has a history of fighting for human rights. He's been detained many times, Your Honor, and we have gone to the High Court and gotten him free. He's been
Your name is
John Manya.
we had written some gift here.
John Manya.
Mr.
Yes.
Yeah. Mr.
John Manya.
John Manya. What do you want to talk about?
Yes.
What do you want to talk about?
Yeah. Your Honor, I just want to refer the court to the classical case of Oscar Sudi versus Republic.
Yes.
Oscar Sudi versus Republic is a 2020 case in KR.
2020 Kerala.
In KR.
Yes.
Where Justice Joel Ngugi opined of the court. Secondly, Your Honor, the charge before you under section 40 of the charge, the proposed, what they are saying they are investigating, so as to charge him.
There is no charge.
It's okay, Your Honor. Yeah.
Yes.
The nature of it, under what has been affirmed by senior counsel, section 40, by its very nature is a capital to 48, is that offense demonstrated to this court that oh, I was really sorry.
I think we have overstated our case.
Yes.
I'd say, in summary, with all these submissions we have placed before, should the court do this? And Article 19 of the Constitution, which emphasizes the centrality of the Bill of Rights, democratic society, so that the functioning of the state and the protection of fundamental rights, the court should lean towards the protection of fundamental rights. Except in exceptional circumstances. I think Article 4 talks about why in fact is required of the state. Whether or not a right should Your Honor, is from what the investigating officer said. Investigations are not. The ODPP doesn't have a reference on which you can make a decision. In terms of the is to protect the right of Mr. Njag. And what does that mean? That these proceedings should be terminated and the file closed. Does that take anything away from the court? I think they are to do with the High Court orders is to go back to the High Court to ventilate what is to happen with the orders in the High Court, because the order cannot vary or review those orders. We can only call for this court. The proceedings should be. Your Honor, it is important. This is a constant practice which is abused. Somebody can be subjected to punishment before a child in court, a requirement for the Mr. Njag to the police order. That is a curtailment or a limitation of its. These orders were, if you had appeared in the first instance, will not be in this. But I really beg that the foundational principles of our constitutional democracy, at the center of it, is the Bill of Rights. In the hierarchy of the functioning roles of the state and the hierarchy of powers as set out in the Constitution, the place for the Bill of Rights starts from Article 1. Article 10 and Article 19. And as my other friends, Babu also set out, that the guiding principles for the judiciary again emphasizes the centrality of the Bill of Rights. And the bottom line, Mr. Njag has appeared as required. So I don't know what the fear is. Mr. Njag does not fear the police, he doesn't fear authority, but he has fidelity to the law, and that's why he's here. When the charges are ready, we'll be here. But from what I've heard here, Your Honor, no sane lawyer will give consent to these facts up here, up high here, on a charge of treason. Finally, we beg that you make the order right away. We have taken your time, but we pray that we leave this court with the ruling made and declared. Thank you.
Those are more than 14 days the state wanted to detain to have the respondent detained. The respondent has appeared today as directed. The High Court has directed that he was to attend to court today. He has done that. From what I have gathered, it would appear that the investigations are not yet complete. The IO does not appear sure on when they will be completed. He is waiting for a report he believes will be ready in about a week. He is not sure about that timeline. So considering that this matter is now before the High Court, which granted bail, and there being no indication on when charges, if any, will be preferred, I order that this file be closed. The respondent will now attend the High Court at the record of the 14th. So this one is closed.
Much obliged.
No, I want to thank the court for its patience because we have had these proceedings and that was exceptional.
Okay.
Thank you so much.
We are really appreciated, so we take it positively.
Thank you, sir.
Thank you. Your wisdom always prevail.
Deal with it, please.
You're most obliged.
kanyaga,
twende kanyaga, kanyaga, na sote tuko tayari. Viva comrades, viva! Viva! Down with Sheria Mbaya, down! Down! Down with Charges Mbovu, down! Down! Up with people power, up! Up! Are you ready for revolution? We are ready. We are ready for revolution. We are ready. Are you ready for Manda Moto? We are ready. Manda Moto. We are ready for Manda Moto. We are ready. Ole yo. Ole.
Right at the outset, praise Bob Njag for his indomitable spirit. There are very few people in this country who have the resilience, the patriotism, Mama Uzalendo, in circumstances where we're dealing with a rogue regime. And Bob Njag, I want to tell you, you are living the true African spirit, because your fights are beyond borders in Uganda, in Tanzania, until every African is free. We are all not free. And until every Kenyan is not free, we are not free. So I want to thank you. I want to thank you, and I want to thank you. I want to thank the legal team for your patience, those who came here earlier. Our marshal now in the courts is Babu, Owino.
Viva Babu, viva! Viva!
Yeah, others were late, but he was here on time. That his diary was all about Bob Njag. You know, last night was all about Bob Njag. You know, last night Babu Owino told me. I was asking him what he's going to do this morning, and he said we must be in Kajiado. And with the team, Njiri, thank you for what you've done, man. Yeah, we must be in this together. But you can see the true nature of the Kenyan state, where the police and the state can take somebody to court, arrest somebody on trump charges. You had the whole story.
Yes.
That Bob Njag has been in custody without a charge and without any investigations which have been concluded. That is the true story of the Kenyan state. So let us continue together, work together until Kasongo goes.
Yes.
Must go. Kasongo must go. But you can only go if you work together.
Yes.
I want to conclude by saying, when you're in the struggle, don't look for rewards.
Yes.
Those are the people who hijack the struggle of people like Bob Njag.
Yes.
Because some people are looking for rewards.
Yes.
Let us not look for rewards. Even for those who have ambition to be in high office, let us not do it outside of the context of the struggle of the Kenyan people, what they really want. And that's why people like Bob Njag count every time that is called upon to come out in the name of the people. He's always there, dependable. And I'm glad I was here this morning to express solidarity with you.
Thank you.
And never, our people united
shall never be defeated.
Our people
united shall never be defeated.
Over to you, Mark.
I want to say that what has happened to Bob Njag tells you how rotten the government system is. Kidnappings are still going on, killings are still going on, and yet the government is competent without justice. And therefore, what has happened to Bob Njag be brought the capital offense to court and not be accorded counsel was most unfortunate, but we thank the court. What has happened now, they have become real custodians of justice here in Kajiado, and we hope other courts will take the same example and defend the law, defend the constitution, and defend the people. I really thank them and thank God for what has happened to Bob Njag. He's a free man now, and I believe he's going to fight this battle and win it. I thank you. Babu.
Thank you, members of the press. I want to take this opportunity to thank the council who are here. They've really done a great job to deliver Bob from the bondage of oppression and from shackles of fear. Bob has been a strong Kenyan fighting for the interest of Kenyans, and he promises that he shall proceed fighting for Kenyans. This charge that was brought against him is a charge that can only make him stronger. The purported charge that was to be brought before him, an allegation of treason, is a charge that is supposed to make him stronger. And therefore, Bob, do not cow. You've seen a lot. You've gone through a lot from Uganda, here in Kenya. But we pray that everything shall be well. Continue with the spirit. The journey is one. I want to thank the courts for delivering a wise ruling, a ruling that has set aside. The file has been closed officially, and therefore Bob is free. He will not face any other charge related to prison because of the reason why, the reason for his arrest. And I want to thank the court so much for, in their wisdom, we are here with Bob, and any other matter that is supposed to be pursued will pursue further in High Court. We have constitutional violations that have, the Constitution has been violated, and we know where to take that matter at the High Court. And we pray that as Kenyans, we continue fighting for Kenyans. Thank you. So let Bob say ya tatu ni kusema asanti kwa mawakili ambao wametuwakilisha kuanzia na Mheshimiwa James Orengo. Asante sana, nashukuru sana wakati wako kwa kufika hapa Kajiado kusimama na sisi. Senator Dan Maanzo amekuwa wakili wetu tangu kutokea kule Uganda, hata tukua kwa Uganda Tanzania, na Mheshimiwa Babu Owino ambaye kila wakati ni kiongozi ambaye tunamtambua, pia ni mwanaharakati. Ningependa tumuingize kwa hii movement ya human rights, manake ni mtetezi wa wanyonge kweli. Namshukuru sana, na si kusahau wakili Eric Njiri na John Maina ambaye pia ni wakili ambao wametuwakilisha kwa kesi hii, na bwana Wesonga pia. Ya mwisho ni kushukuru shirika za haki za binadamu kuanzia Defenders Coalition kwa kupatia cash bail ambapo tunahitaji. Nakumbuka pale Kitengela vijana zaidi ya 120 walikamatwa na wakaletwa hapa kotini wakashtakiwa na mambo ya kuandamana. Shirika la Defenders Coalition ikishirikiana na LSK wameweza kuwapatia cash bail na wale vijana wako huru hivi sasa.
Very good.
Kutetea wananchi na kushirikiana na viongozi mbalimbali ili tuweze kukomboa taifa yetu kutoka uongozi wa jumla na wa dhuluma. Asante sana na Mungu awabariki.
Nashukuru pia. Asante sana. Mungu
Viva comrades, viva. Viva. Viva comrades, viva.
Viva.
My name is Sunguoyo. I'm the national spokesperson of Kongamano la Mapinduzi. What we have seen today basically is the weaponization of the law by the Kenyan state against innocent Kenyans. I think the state must never be scared of the citizens. these are signs of a state that is in panic mode and which is ready to take measures against people, innocent people. Sisi tunachosema ni hivi. We know that a lot of our compatriots, a lot of young people in our generation have been facing persecution in different parts of the country. We are ready to move across the country to extend our solidarity and make sure that they are free, because we know that they are innocent. The only crime that our generation has is dreaming of a better Kenya and struggling to achieve this new society that can guarantee us justice, that can guarantee us dignity. Tunasema tutazidi kusukumana mpaka tuzalishe hiyo Kenya mpya ambayo inaweza tupatia justice na dignity. Tuzidi kukaza kamba, tuzidi kuresist dhulma. Lazima tukae kwa sababu sisi ndio wa Kenya na tunajua article 1 natuambia all sovereign power
belongs to the people.
Who are the people?
We are the people.
So lazima tuendelee kukaza kamba na hii barabara ambayo tumeianza dhidi ya dhulma, dhidi ya koti kutumika vibaya, tukomeshe hiyo kwa sababu we do not want to go back to the dark days of the Moi dictatorship, of the KANU dictatorship. Mwananchi unamletea charge ya treason, a treason charge. Treason is not a small charge. Treason is not a small charge. So to the young people of this country, let us keep on keeping on until that day when we arrive at a point of victory against this oppressive system.
Kwa sababu tunakuja. Viva.
Oh yeah. Okote de amore. Yeah. Oye, vaya a decir que me acabo.